Welcome back to Native American Studies 299 499 here at Sitting Bull College, our Tribal Sovereignty and Contemporary Supreme Court Jurisprudence Special Topics Survey course. I'm your instructor, Kara Damari, and today we are looking at Washington State Department of Licensing versus Cougar Incorporated, a 2019 U.S. Supreme Court case. As always, we will be making our way through the parties, the issues, the procedural posture, and the rule or holding. And like in some previous cases, we'll actually go through the opinion announcement via OYA, because in this case particularly, it's probably a more structured way to go through that. So we'll incorporate all of these components as we go through that opinion announcement. But let's note our parties first. On one side of the V, we have the Washington State Department of Licensing. We can see them here in their website, or the website as it is now. And then on the other side, we have Cougar Den. And who is Cougar Den, you might ask? Cougar Den is the fuel distributor within, or is a fuel distributor, tribal fuel distributor within Washington State. And you can see here their website. They're located primarily in White Swan, Washington. And you can see that they do a variety of fuel transport services, and that they are Native owned. Actually, I'll show you their about for a second. I believe they are 4 generations. Let's see. Yeah, so they employ over 150 people. You can see some of their current employees right there. But they've been around for over 40 years and are rooted in the Yakima Reservation in the state of Washington. So this is Cougar Den. And where did this case start? This case started, oops, this is the wrong link. 1 second, please. All right, I apologize. Here we go with the correct link in there. I'll link this up too. So we have here an initial, let's see here, we have here the initial hearing rules, basically in favor of the importation of fuel to the Yakima Indian Reservation in 2014. And we see the exhibits, the issues, the result, and the findings of fact. We see that we have the Yakima Nation, which are a federally recognized Indian tribe established, or the Yakima Reservation established by treaty in 1855. We see that there is a ceded lands associated with this treaty and with the reservation. We see that the Yakima Nation is the governmental authority on the reservation. And we see that the owner of Cougar Den is an enrolled member of Yakima, and that Yakima is actually a privately held or a privately owned, but Yakima Indian owned corporation incorporated in Yakima Nation. Their business office is located within the reservation as well, and they're registered as a foreign corporation with the Washington Secretary of State. All right, so we see that in 1993, the Yakima Tribal Council issued Cougar Den a petroleum products license responsibilities document, that they've held also a motor vehicle fuel dealer's license from the state of Oregon, that they were issued a bulk user petroleum permit by Yakima Nation, Cougar Den was, and that they've never applied for nor held any type of motor vehicle fuel license or special license by the state of Washington. And I'm going through this because when we get into the opinion announcement on OYA, although there is a good amount of the case history that Justice Breyer talks about, he doesn't necessarily go through some of these initial facts. And I think that they're interesting and relevant to sort of understanding the underpinnings of this case. So we see that in March 2013, Cougar Den begins exporting gasoline from Oregon into the Yakima Reservation. All right. They file reports for the Oregon Department of Transportation showing how much gasoline they're exporting. And we can see that here, both gasoline and diesel, starting in 2013 March through October of 2013. And we see that it's, you know, it starts sort of lower and ends up being about 500,000 gallons of gasoline and a third of a million gallons or 351,000 gallons of diesel. So we see that these trucks are leaving the state of Oregon and going to the Yakima Indian Reservation at all times being within that ceded territory. We'll show a map of that and we'll discuss that in a second, what that ceded territory of the Yakima Reservation is. But it tells you their exact route there. And so they're going basically right from Oregon to where they have whatever license and whatever else to Yakima Nation, where they also have, uh, whatever license or ability. And so this is where the case kind of begins. Let's go back. So remember, an important part of what we are trying to do here through this course is, well, we're focusing heavily on the tribes because this is a Native American Studies course, and so that's why we talk so much about the treaties and a lot of the information related to the tribal rights. And in this case, we're going to be looking at some language that was used in the treaties and how the tribe would have understood that. But also, we want you to have the tools to be able to go and find one of these cases on your own. So if you hear about a Supreme Court case involving an Indian nation or a tribal nation, and you think to yourself, well, I wish I would know more about that case, Oye is one of those tools for you to do that. And you can do this on your own. You don't need me to post a link in my SPC. You absolutely can get there. And so let's just do a brief run through of that. So say we know nothing else, we're just going to oye.org. And then we have heard about this case, something about a cougar den. All right. So we're going to look up cougar den and boom, right there. And I even spelled cougar correctly, but I suppose even if you hadn't, it might go through. So we see right here, Washington State Department of Licensing versus Cougar Den. We're going to click on it. And again, just to look around Oye for a second, we can see we've got the ability to listen to the oral argument over here on the left. If you recall in an email last week, I mentioned that this is not an oral argument, which is necessarily the most helpful to listen to in understanding this case on the level we want to understand it. It really gets in the weeds. The other thing about this oral argument is, unlike previous cases that we've listened to, there are in fact three advocates. There's an advocate for the Department of Licensing, there's an advocate for the Department of Justice, and then there's the advocate for Cougar Den. And so it gets a little bit confusing. And the two male advocates, may sound a little bit alike as well. So if you want to try to listen to that one, this is great. Or if, for another case, if you hear a case is happening and you want to go and say, oh, what happened there? It's easy enough to put this on via Bluetooth while you're on the drive somewhere or whatever else and get a taste of some of these other cases. Also, on the left-hand side, we can see the opinion announcement, which we'll be getting to in a second. And then we've talked about the syllabus before, and then we can see the opinion of the court. In this case, we have a plurality opinion, and I'll talk about that a little bit later. But we also see a concurring opinion there. We see two dissents from Robert and Kavanaugh. So those are available for you to read via this platform as well. So I recommend, if you happen to know a name of a case that you're interested in finding more about, this may be a nice place to start. So let's open up the opinion announcement. And as I mentioned, we're going to go through this today, and I'll be stopping many times, many times throughout, and we'll be looking at some additional information. So.
And Justice Breyer has our opinion in case 1698, Washington State Department of Licensing versus Cougar Den Incorporated.
True, but it is opinion for three of us. It's a plurality. And there are two others who do concur. All right, now, what is this about? It's in 1855, the United States entered into a treaty with an Indian tribe, the Yakima Nation. And at that time, the tribe owned and occupied most of what is now the state of Washington. Now, in the treaty,
so this is a good place to start. 1855, the Yakima Nation entering into a treaty with the US. We remember that from Washington versus the United States, that this is a Stevens Treaty, right? Isaac Stevens, you remember him. All right. At that time, the tribe owned and occupied, as Justice Breyer says, what is now the state of Washington. And we can see that a little bit here. So we see, this is from Yakima Nation's website. It is a map of the ceded area and reservation boundary of the Confederated Tribes and Bands of the Yakima Nation. And if we zoom in over here on the right, we can see what is the present day border of the state of Washington, and inside what that area looked like at the time, which clearly makes up a good chunk of the present day state of Washington, right? And we see a sort of a nice image of that here. So we've got the ceded area on the outside, and then we've got the present day reservation, the smaller blue there. All right. And if we go back to the Yakima Nation's website, or that was yakimanation.com. I think this is yakima.com. If we go to the Yakima Nation's website, which is this side, I believe, and they've got their logo up there, we see this Yakima Nation Treaty of 1855 laid out in easy to read font right on their website. If you have anything to do with a tribal website, this is a quite nice thing to be able to find so easily. And Yakima Nation does a great job of displaying this. So it's a good example for tribes that don't maybe have their treaties online if they'd like to do that. And we can look at the various parts of the treaty, and we can see that Article 3 reserves the right, or not reserves, but treats for the right for Yakima Nation to travel upon all public highways, all right, in common with the citizens of the United States. And that second part of that phrase we'll look at, or that second phrase we'll look at more, and the opinion we'll look at more in a minute, but we can see that located clearly right here in Article 3. We've also talked about, if you recall, in previous cases, this right of taking fish at all usual and accustomed places, right? And that usual and accustomed places, that has a similar specific meaning in these treaty cases, as does this right in common with the citizens of the United States, all right? So, and we see that in common with the citizens of the territory. So we've talked about that right of taking fish before. We talked about that in the Washington State culverts case, and then we've mentioned, or I believe I included in an email, mentions of multiple other cases which have looked at that language, or treaties which have looked at that language. So we see that in any case, we see the right to travel here in Article 3 of the Yakima Nation Treaty of 1855. Let's go back to Justice Breyer. And it's important to note that look at the size of this area, right? I mean, if you were treating, if you were making a deal to give up this much area, then you'd be making sure to get quite a bit in return, right? And yes, we know from Isaac Stevens' history that he was perhaps more than miserly in terms of what he provided Native people in return at times, but clearly the tribe would have argued for substantial you know, substantial rights or substantial some sort of compensation or other things in giving up this much land, right? So back to Justice Breyer.
The Yakimas agreed to cede part of their land to the United States. It happens to be about, I think, about a third of the state of Washington, in return for $200,000 and certain privileges, including, quote, the thing at issue here, quote, the right in common with citizens of the United States to travel upon all public highways. End quote. Now, in 2013, Washington, its tax department, charged Cougar Den, that's a member of the tribe, $3.6 million in taxes for importing fuel into the United States by ground transportation.
All right, we discussed that before. So we have Cougar Den, who, just as Breyer is denoting, is a member of the tribe, importing fuel, and the state of Washington charging them $3.6 million in taxes. And if you recall that chart we looked at, the amount of fuel that they imported over those months in 2016, that's sort of what we're starting to see Washington State try to tax the Cougar Den, this tribal member, as Justice Breyer denotes, for importing that fuel via ground transportation. So using trucks, right? This is not a situation, and we hear this mentioned in the oral argument, where we have some sort of plane drop of a pallet or some sort of drone activity, all right? They are driving through Washington State.
In particular, that wholesale distributor, it's owned by the member of the Yakima Nation, transports fuel over Washington's public highways to the Yakima Reservation for sale in the Yakima-owned retail.
Okay, so the fuel is going through Washington State to Yakima-owned retail gas stations, right? So these are gas stations owned and likely licensed through the Yakima tribe and on the Yakima Reservation.
Gas stations. So we have to decide whether the right to travel provision in the treaty preempts and thereby invalidates this tax on the Yakima fuel importer.
And we've talked about the word preempts before. It's similar to the word precludes. It just means prevents or prohibits, right? So does the right to travel in the treaty, and we've looked at that treaty, we've looked at Article 3, we've seen that right to travel, does that stop the state of Washington and thus the state of Washington can't enforce a tax on Yakima fuel importers?
We conclude that it does. Now, we rest this conclusion upon four considerations taken together. First, the Washington statute, you have to read that statute. It taxes the importation of fuel by public highway, but not by pipeline, not by airplane, there is such a thing, not, in other words, by other methods.
So let's pause there and look back. I have pulled up here the brief of the respondent on writ of certiorari to the Supreme Court. So the brief of Cougar Den, and we're going to pull it up right on the Supreme Court website. And you can find so many of these things using supremecourt.gov. And so that's another resource for me to reinforce today. And we see in this brief, it's rather rare to find images or maps or even maybe charts in briefs, but it can be very helpful, and we see it used especially helpful here. On page 9 of the brief, we see this chart showing the road that they are taking. All right, so we see that we have the Yakima Nation, in the dark green, the current reservation, and then we have the Yakima Nation ceded territory in the lighter green. We see that there is a 27-mile trip between the border of the Yakima reservation, the present day reservation, through the ceded territory to the state of Oregon, all right, or Oregon. Uh, and so 27 miles, but they're going through the ceded territory. Doesn't matter if they're going through the ceded territory. Well, we can look back to the treaty and we can and sort of listen more on that. We do see that this mentions that roads may be run through the reservation. Free access on the highway is secured to them. This is the nearest public highway, so it doesn't even mention necessarily that it has to be ceded territory. And it does say on all public highways, all right? But we note here that, in fact, this is going through this ceded territory in particular for 27 miles to the Yakima Reservation border. What can you kind of note about 27 miles? Well, one thing about 27 miles is you probably don't need to necessarily stop for gas in 27 miles either, do you? So this is a short trip where these trucks are probably just driving straight through, right? All right, let's get back to Justice Breyer.
The statute says there is a tax, quote, on each gallon of motor fuel that enters into the state, but only if the entry is by means of, quote, a rail car, trailer, truck, or other equipment suitable for ground transportation.
So what Justice Breyer is doing right here is differentiating basically the right to so one of the factors in this case was what the taxable event is, and Justice Breyer's differentiating the Washington state statute that taxes on motor fuel via, if the motor fuel is being entered into the state by means of is being entered. I don't think that's the way people say things. If the motor fuel is entering the state by means of rail car, trailer, truck, etc. And and so then he goes on to say, and we'll hear this in a second, that the Yakima business, this Cougar Den, owes the tax only because they're traveling with fuel on the public highway. All right.
So they owed the tax only because they traveled with fuel on the public highway.
So it isn't.
Now,
It's almost
this court.
and we didn't differentiate, but it's almost this question as to whether it's an import tax or not. All right. Um, uh, I'll leave that alone for now. I don't think it's necessarily relevant to us coming to what the court's opinion is in this, or for us understanding the court's opinion, in reference to other tribes or things like that, and that here. But just noting that if you consider tax in states, sometimes states have different tax schemes related to import taxes as opposed to some sort of transportation tax. And then oftentimes they'll try to refer to what the taxable event is. So that's what they're talking about when they're mentioning that.
It's considered this treaty 4 times before. Each time it has considered language very similar to the language here now before us. Each time it is stressed that the treaty must bear the meaning that the Yakimas understood it to have in 1855. Why? Well, because the parties.
All right, so the Supreme Court, Justice Breyer mentions, has considered this treaty. This is the Yakima Treaty of 1855, or it's just the Treaty of 1855, I should say, but that Yakima Nation is a party to 4 times. Let me show you quickly those other times. We have talked about them a little bit before. I included them in an email, but we've got a 1905 decision, and we see in this opinion, let's look back at the language here. We are looking for the language, as Justice Breyer notes, in common with, right? So we're looking at this treaty language that in common with the citizens of the United States, and how the tribe would have understood that to relate to the public highways. And we can see in this 1905 opinion. Uh, let's see here. This is they occasionally in these older opinions, they actually include the argument within the body, not body, but within the document of the opinion. And so uh, here we can see Justice McKenna in 1905 delivering the opinion of the court. It's kind of hidden in some of these, so you really have to look out for it. I know in many of ours it clearly says opinion. But we note that Justice McKenna does mention uh, the construction of the second paragraph and this use of the words in common with the citizens of the territory, right? All right, and he notes that the respondents, who is the or who is not the United States, who are on the other side, are saying that those are rights only as a white man would have under the conditions. All right, and uh, this is sort of this argument about whether or not it's a discriminatory phrase, which we'll talk about the fact that it isn't in a second. Uh, and we see the court coming down on the sides of basically saying that this should be interpreted, they use this word, as the unlettered people understood it. All right. And they mean that to, I think, basically say as the people who weren't those who are the ones who were writing the treaty in that language. And in fact, we'll talk about the language, Chinook, this jargon that was used in some of the negotiations later. Uh, but this is in 1905, and this Justice McKenna is mentioning we will construe a treaty with the Indians as the unlettered people understood it. So this is one of what we've called the canons of construction, or the canons of understanding, I suppose, Indian treaties, treaties with native peoples. We are going to look from the Supreme Court is going to look at them and look to understand them as the tribe would have understood them. In many cases, as we know from Isaac Stevens, the governor of Washington Territory at that time, if you recall, he's the one who sort of formed this treaty party. He's going into it with his government representatives and maybe lawyers and maybe whoever else. And then on the other side, we have the tribe who are, as Yakima did here, treating for an enormous amount of land. All right. And we had a student mention in one of our discussion groups that when we talk about the tribe, we are talking about those specific members who were present at the treaty negotiations or who were engaging in these kind of negotiations. But we are using that here. So this particular case was about fishing and hunting. I won't go into it too much, but basically the court concluded that the 1855 treaty, includes the tribe's individual right to fish and hunt and other privileges. All right. We had on one side, there was a state licensed fishing operation that was on land that I believe the individuals had homesteaded and was near the falls that we've talked about before, which are part of the Columbia River, which are really at the base of many cultural, historic, religious, and other practices that because they are part of this salmon run, right, of the Yakima and then also other tribes within the region. In this case, the state licensed fishing operation got a license from Washington State. They had this fish wheel. Basically, a fish wheel is this device you put in the water. Fish swim into it, and it sort of catches them. And you can catch many fish, and they keep them kind of underwater in this net usually. And you can really drain a river of fish if you have a big enough fish wheel or enough fish wheels, and you can kind of take away the fishing supply of the Yakima, and that's what was going on here. And they also, I believe that they were forcibly stopping Yakima tribal members from crossing their land in order to get to their traditional tribal fishing grounds. Okay, so we see, as I mentioned, the court looking at this, and I still have that up here, as the Yakima tribal members, who it describes as the unlettered people, understood it, and mentioning that in looking at the negotiations with the Yakima, even in 1905, when this case was being decided and argued, that it was clear that the district court had found that at the Treaty Council, the United States negotiators promised and the Indians understood that the Yakimas would be forever, or would forever be able to continue the same off reservation food gathering and fishing practices as to time, place, method, species, and extent as they had or were exercising. So it's interesting, actually, that in this case they did pull some of that history, right? And they pulled the direct, or they examined the actual negotiations that went on during the treaty. And this is in 1905. In cases now, in 2020, 2021, it seems so hard sometimes to get those materials, but trust me, if folks could do it in 1905 without the internet and having to take whatever wagons, I suppose, to archives in different states to gain access to these treaty documents, it is very possible to do today, especially with the internet and whatever else. So, and it's important to do, as a tribe, uh, to bring forward some of that proof from the negotiations of how the tribe understood things, or what was occurring at those negotiations, because sometimes, not sometimes, most of the time, those negotiations were, uh, you know, had a lot of different things going on. So that's this one case. We also see, again, we're mentioning these cases because Justice Breyer talks about the fact that the Supreme Court has looked at these cases four times, or this treaty, this 1855 treaty, four times before, and each time it has considered language very similar to the language that it is considering here in Cougar Den. So the second case that we'll look at is this 1942 case, all right? And this case is similar to our other fishing cases, but here we see that the Washington state is forcing, and we'll see Justice Breyer mention this case in a minute, but Washington state is forcing a Yakima tribal member to get a fishing license and pay money to get it. In fact, not just get it, but pay money to get it. And he hadn't obtained a fishing license, and Washington state tried to say that he needed to have. And so the court in this case looked at the treaty again and found, let's see if I can just search it in common. Found that, and referred back to the 1905 case, found that this particular phrase, "in common with," had been litigated in the US Supreme Court, and also that it was still in 1942, and continues to be, the responsibility of the Supreme Court to see that terms, if previous courts or previous bodies haven't, to see that the terms of treaties are carried out so far as possible in accordance with the meaning that they were understood to have by the tribal council representatives or by the tribal representatives at the council, the treaty council, they mean, and in a spirit which generously recognizes the full obligation of this nation, the United States, to protect the interests of a dependent people. Remember, dependent people refers to the tribe. Here we have this language that US Supreme Court has used and other courts have used, this of domestic dependent nations. And so we saw in 1905, we saw this word unlettered. Right here we're just seeing this word dependent. But we see again, it is our responsibility to see that the terms of the treaty are carried out so far as possible. And I know I'm reading this again, but it's because this has been made clear in accordance with the meaning that they were understood to have by the tribal representatives at the council, the Treaty Council, and in a spirit which generously recognizes the full obligation of this nation, the United States, to protect the interests of the Yakima or of the tribe. All right. And then they view the treaty in that light, and they do ultimately determine that the 1855 treaty, and we saw that fishing language right under our public highway language, right? That 1855 treaty does in fact secure Yakima tribal members the exclusive right of taking fish in all streams running through or bordering the reservation, and right of taking fish at all usual and accustomed places in the state of Washington. Uh, so then we see a third case, and we'll get to our fourth in a second here. We're taking a long way, and actually the fourth is going to be the first one, but we're back. We're kind of jumping around chronologically for some reason, mainly because I ordered them this way, apparently. We're back in 1919, and again, we see this language. So this is after 1905, before 1902, but we see this language, the right of taking fish at all usual and accustomed places, in common with the citizens of the territory. And again, we see how the Indians understood this proviso we are considering is not doubtful. Okay. During all years since this treaty was signed, they have been accustomed habitually to resort for fishing to the places to which the degree of the lower court applies. They have shared such places. This clearly shows that their understanding of the treaty was that they had the right to resort to these fishing grounds and make use of them. All right. And we see that, you know, they can't be restrained, all that sort of thing. All right. This is our 1919 case. And now back even to this 1889. Oh no, it is 1887, I think. Yes, 1887 case. I've pulled this case here. Be clear, you can find these cases, even if it's not online easily, even if it's not in OIA, even, if you feel as though you might struggle, reach out to myself or someone else, or, go to your state historical society or your tribal historical society, if you have one, or the national historical, whatever, and just ask. I need to find a copy of a court case from 1887. I need to find a copy of a treaty from 1885, and someone 1875, 1855. Someone will help you out. All right. So we see in this case, the Supreme Court, this is 1887, the Supreme Court saying, we think that the contention of the appellants must prevail, as it seems to us that the Indians, in making the treaty, would have been more likely to have intended to grant only such rights as they were to part with, rather than to have conveyed all, with the understanding certain rights were to be reconveyed to them. What do the Indians intend to reserve to themselves by the words, as also the right of taking fish at all usual and accustomed places in common with the citizens of the territory? It will be seen by the statement of facts above set out that at the time this treaty was made, there existed within the territory, which was the subject matter of the treaty, certain ancient fisheries which had for generations been used as such by said Indians, the Yakima, who had certain well-defined habits and methods connected with such use. And it is contended on the part of the appellant that the effect in the words above quoted was to reserve to the Indians the right to enjoy all of these fisheries as they had heretofore. And the other side says that it's not. And the Supreme Court, again, has dealt or this is actually one of the earlier cases, maybe the first case, which looks at this language. And the Supreme Court, again, takes into consideration all these facts and looks at what the Indians would have been trying to preserve, and looking at that they would likely be trying to preserve these rights as fully as possible, right? Rather than to provide, and I didn't highlight it here, but rather than to provide a new right to be enjoyed in unknown ways. All right, so they were reserving things that they already understood, and this was the way that they had been doing things. So that's what Justice Breyer is talking about when he says, and I think it's important to note, but each time in the 4 times this treaty has been considered, the language has been found, and it has in fact been stressed. We saw some real strong language from the court that the language in the treaty has to be considered as the Yakima would have understood it in 1855. Back to Justice Breyer.
Considered this treaty 4 times before. Each time it has considered language very similar to the language here now before us. Each time it is stressed that the treaty must bear the meaning that the Yakimas understood it to have in 1855. Why? Well, because the parties negotiated the treaty in the Chinook jargon, which I gather is a trading language of about 300 words, that no tribe used as a primary language. 2,
all right, let me tell you a little bit about the Chinook jargon. I think I have a slide here. So basically, Chinook or Chinook, I believe it's pronounced Wawa, or they even just called it this jargon, is this type of pidgin, which is when you combine multiple. Pidgin is basically means if you combine multiple languages, or if you dramatically simplify languages used by a couple people. They're not usually considered complete or full languages by linguists, pidgin languages. And so Chinook jargon is this sort of pidgin trade language that was going on in the Pacific Northwest during the 1800s, particularly in the areas from around the Columbia River, around this trade route in present-day states of Washington and Oregon, and then even up further north and a little bit more west. It's a small language, as mentioned. It's a trade language. It's not actually an independent language, but it's this sort of mix. Maybe mix isn't the right word, but combined language that takes into account just what is needed for certain trade things, probably, and in large part the Chinook language, or this Chinook jargon, uses a lot of French words. All right, it has, I think, like 20%, 15% French words, and it's written in this shorthand that was developed by a French priest. All right, so we see a little bit of that on the right in this slide. So that's the language that Justice Breyer is talking about here, and that's how they're negotiating. And again, we've got the Governor Stevens on one side, and we've got the tribe or tribes on the other side. And then we see him mentioning that they wrote it down in English, right? And that the Yakima couldn't read or write English, and maybe couldn't understand it before, beyond that. Let's remember that in addition to English, the Yakima were also contending with the French at this time. We have this jargon being used that was developed by this French priest, or French, was he a priest? I don't remember. I think he was a priest. And then we might even have some Spanish, and we've also got different tribal languages in the region. So it's not neither here nor there that the Yakima, weren't speaking English. And I don't think that Governor Stevens was speaking the Yakima's language either. But English is the language that this treaty was written down in.
Wrote it down in English, a language that the Yakimas didn't understand at all, or at least they couldn't read or write it. And 3, many of the representations that the United States made about the treaty had no adequate translation in the Yakima's own language. And so, taking that into account, Those cases have over and over read the treaty's guarantee of, quote, the right of taking, for example, fish in common with citizens of the territory to be much more than just a right against discrimination. We've held.
What does a right against discrimination means? It doesn't mean that the Yakima are being discriminated against. It means that if you were to, I thought I should put a slide in about this and I wasn't sure if I was going to, but I'll just fill you in real quick. If you were going to look at this language, in common with the citizens of the United States, you might be tempted to read this language as meaning that basically the Yakima were trying to secure that they wouldn't be subjugated to a lesser right than the citizens of the United States. That would be an incorrect way to read this language. As those previous court cases we mentioned noted, this is language which would not have taken away more rights or would have changed the way the Yakima would have understood the rights, right? This is language that would have secured to them what they had at that time, because that's why they were securing it. And so we can't read it in the sense that they were trying to prevent themselves from being discriminated against and obtain this lesser right than they actually had. We have to read it in this way that they were keeping this right that they already had, and they were in fact writing it down as such.
But reading the treaty is giving the Yakimas only anti-discrimination rights. Now, rights that any inhabitant of the territory would amount to, quote, an impotent outcome to negotiations and a convention which seemed to promise more and give the word of the nation for more than that.
And we remember how much we're negotiating for, right? We're negotiating for this enormous swath of land and ceding this enormous swath of territory.
Third, the historical record indicates that the treaty negotiations and the United States representative's statements to the Yakimas would have led the Yakimas to understand that the treaty's protection of the right to travel on the public highways included the right to travel with goods for purposes of trade.
So it's important in many of these cases to look at the historical record, and we see that being brought forward frequently throughout the litigation. Sometimes at the trial court or district court level, it doesn't actually include as much of the historical record, because frequently there's less of an idea of that case may go up. We remember in the case of that Spirit Lake case, actually it was a Turtle Mountain member, right? When he initially filed that separate sovereigns doctrine case, or when he initially appealed based on, I don't remember, I should phrase this more correctly. Let me think about how to say this for a second. In that case, we had the defendant, the gentleman who was a tribal member of Turtle Mountain, who was on the Spirit Lake Reservation, claiming double jeopardy, right, at that level, but not including a lot of the history or other things at that level. And so that's an example of how, as the case goes up, you start to see more of the historical record. And he just had a public defender. The public defender wasn't trained in Indian law, didn't, do whatever necessarily. But we do see that in these cases. I'll show you just quickly. We can actually, so I've mentioned already OIA, and I've mentioned going to the Supreme Court's website, but another tool is, again, it's actually through the Supreme Court, but they provide some of what you might consider almost like the judicial history. It is actually, you might not consider it, it is the judicial history of this case, but including a lot of the documents. So we see here this case, and you can find this at this URL or by looking on the Supreme Court website, and we see the questions presented. We see when it was moving up. This is through went through the Supreme Court at Washington, and it actually includes all of these documents. So this is a free, publicly available data source. And if we look at, you can see some more information on who was a part of this case, and even their telephone numbers, their email addresses, their addresses. So if you happen to, be experiencing something similar and want to get a hold of one of these guys or whatever else, this is, a means of which, as if you are, say, working for a tribe and you want to do that, maybe to find that information. But let's look at this uh, amicus brief of the Yakima Nation in support of the respondent. And why might the Yakima Nation be included in the amicus brief? Well, because Cougar Den is the party, right? But the Yakima Nation has a huge stake in this litigation. And so the Yakima Nation wants to make sure that they provide a history of our people, the Yakima Nation, and of the negotiations in the treaty. And so that's what they do here. There are other briefs that provide more of the history, but we're going to look at it in this brief from the Yakima Nation. We see their argument, and we see that since time immemorial, travel and trade have been central to Yakima culture and traditions. And they go through that. They're citing different sources. All right. Our ancestors, given their central location, were a linchpin in a well-defined trading network. And so the Yakima have long traded in this region and traded in these routes. Territorial Governor Isaac Stevens knew the importance of trade and travel to our ancestors prior to negotiating the treaty. And so they go through and evidence that the tribe does. The treaty signatories understood the Article 3, and we know which article they're talking about here, right? Article 3, right here. It's not very long. We see the Yakima Nation saying that the treaty signatories, and we see those signatories, let me scroll down to those for a sec. Here they are. Oftentimes they did sign with an X, which shows even further that, they're not writing in English, right? Yet English is being the language in which this treaty is being negotiated. The treaty signatories understood Article 3 to reserve the right to continue traveling and trading as they had before the treaty. All right. And it talks about, the brief talks about various incidences that occurred, and that it was clear that this was what was understood at the time and understood during the treaty. They even quote different language where Governor Stevens mentions, you will be near the Great Road and you can take your horses and your cattle down the river and to the Sound for market. All right. This is very similar to that Washington state statute, which is talking about, imposing taxes on goods that are being transported. But then also this entry stuff, they're bringing it into the other state or whatever. You will be allowed to go on the roads to take your things to market, your horse and cattle. You shall have the same liberties outside the reservation to pass your animals, etc. Right? And so that language is even language that Governor Stevens had used. And so we see a lot of that history. The Yakima Nation's right to travel includes the right to trade free of encumbrances. And so it's helpful that the Yakima Nation has stepped in here and provided this historical information on both, the treaty negotiations and how the Yakima would have understood the treaty and sort of the Yakima at that time, right? All right.
That seems they've said that over and over. And third, the historical record indicates that the treaty negotiations and the United States representative's statements to the Yakimas would have led the Yakimas to understand that the treaty's protection of the right to travel on the public highways included the right to travel with goods for purposes of trade. And that seems they've said that over and over. And it might be cattle, it might be buffaloes, but it could be fuel. Fourth, the state of Washington's imposition of a tax upon traveling with certain goods, in our view, burdens the right to travel with goods. For example, in 1942,
we talked about this case.
We said that, and there's a reserved fishing right in the treaty, but we said that the state couldn't require the Yakimas to do what everybody else had to do who fished, buy a fishing license. It cost $5, I think. So if that $5 fishing license burdened the right to fish, We think a $3.6 million tax burdens the right to travel with goods here fuel upon the highways. All right, we conclude that following our earlier cases, Washington's fuel tax cannot lawfully be assessed against Cougar Den because, quote, it acts upon the Indians as a charge for exercising the right to travel on highways with goods that their ancestors intended to reserve.
All right, and that brings us to the end of the case, right? And remember that the opinion announcement does not dive deep into all the parts of this case. For that, you can go, it's in your MySBC, but also you could find it via any of those means that we've talked about, the opinion. And as we've mentioned in previous weeks, you go past the syllabus and you get to the opinion, and you see that here. And you can look more closely at, when you're reading through this opinion, and maybe you already have, some of the specific points Justice Breyer has just noted. Also, if you happen to have listened to the oral argument, some of how the Supreme Court has addressed those arguments by the state of Washington or the Washington Department of Licensing are included here. And so the Supreme Court actually looks and goes through those exact things in order to provide more value in this opinion, right? This is going to be an opinion that people can look back on as the Supreme Court, as people do look back on these US Supreme Court opinions. Okay, so I should mention that if you want to find more information, a third or fourth source at this point that you could go to about this case would be Turtle Talk. We've talked about Turtle Talk before, and you can just go to Turtle Talk. You could look up Cougar Den and you could find, or you could look up this 1855 Yakima Treaty, and you can find a whole bunch of cases related to the a whole bunch of postings related to the 1855 Yakima Treaty. And within those postings, you can find a significant amount of these materials. So this is, for example, the background materials in this case. And you'll note that they include various replies, supplemental briefs, all of this information. So this is a fairly clean and easy way to get to a lot of this information, also presented generally by Matthew Fletcher, who's Indigenous himself. So a nice means to get to this information vis-a-vis Turtle Talk. All right, with that, I will look forward to seeing everyone or whoever can make it on Wednesday night for our tribal sovereignty discussion group at 4:30, and have an excellent week. Thank you for joining today.